We got 88 people. I think it's a good time to start. So my name is Peter Hecht. For those of you that I have not met before, I am one of the founding partners of Magna Legal Services, and I head up the sales, marketing, and some of the front office operations here. And we're about 14 years young. I don't know if I told you that, Bill, but we're going to be celebrating our 14th anniversary this month, which is pretty exciting. So I'm going to invite you, Andy, Chad, and you, Justice Medina, and Bill, to our virtual party, and Erika is going to be the host. We do these programs. We've been doing them now for about a year, Justice Medina, where we do these free webinars. They're informational. They're highly interactive. By the way, everybody in the audience, there's a chat bar at any time during the event. If you want to interrupt with a question, I can't guarantee you that they're going to answer them. Feel free to ask a question. We really do like to have these mimic the way we do the bricks and mortar Magna events, where people kind of raise their hand and we've got the roaming microphones going around. So it's the same kind of theme, here, but it's just virtually. I mean, it's totally lame compared to the real deal, but this is like, we're the coolest lame people around, at least on the Magna webinars. And we're going to be super cool on October 7th when we host our first bricks and mortar event at the W Hotel in Miami. So you're all officially invited. It's called the Battle of the Experts. Again, for those of you that don't know who we are and what we provide, Erika, I'm going to give you 30 seconds or less. Why don't you give the audience a little plug as to what it is that we wish we could be selling them in person, but we're doing it over the virtual net.
Absolutely. Thanks, Pete. For those who don't know me, I am Director of Business Development here on the West Coast. We are an end-to-end litigation consulting and support provider. We can help you with national court reporting company. We have our own internal record collection, internal language services, not just interpreters, but document translations as well. Andy, you have an employee handbook you need translated? Let us know. We can help you. We're an award-winning jury research provider. We do everything from in-person focus groups, mock trials, damages assessment. Let us help you prep your witnesses. We can help you during voir dire and jury selection as well. We are also an ALM award-winning graphics consulting and design company. We can help you set up a sweet PowerPoint like Bill's going to show, or help you with an entire 3D animation. We also have our folks who normally sit at trial and run all your tech in the courtroom so you can focus on telling your story. But right now, those hot seat guys are running exhibits during depositions. So if you need help with that, call me. And we also do some social media surveillance, Pete. You want to know what one of your plaintiffs is saying, Chad, about your case? We'll do a search for you.
Yeah, I want to know what my kids are doing on social media. Probably not, actually. Right?
No, you don't.
Actually, Bill and Chad, we actually thought about rolling out a program called Spouse Scout when we came up with our social media surveillance program for the family law practice, but we never did do that. For virtual depositions, I don't know if you've all been taking depositions. And by the way, Magna Legal Services loves to cover construction defect depositions. We've got the virtual data room. We do, and we want you to call us. We could work out the defense group programs. We've got the virtual data room to warehouse all of the documents, which I know is super important for the construction defect cases. But most importantly, during these crazy times, we provide all of the virtual services at no additional charge. So you don't have to pay any kind of special fee for the virtual platform, for tech support. Any kind of training, it's all included at no charge. And then additionally, you can pick the platform that you want to be on, whether it's Zoom, WebEx, Cisco, Microsoft Teams. We make it really easy, Bill. So Bill and Chad, when you're scheduling your depots, think about Erika, think about Magna, and Andy. I know that you remind your counsel to think about it. So we're super grateful. Thank you for being here today. We've got a great moderator. I don't know if you all have met Justice Medina, former Supreme Court Justice of the Lone Star State, Texas. I want to hand the meeting off to you, David. Thanks for joining us. I love that. That's a 12-pointer behind you.
It's grown to an 18-pointer since we last spoke.
It's an 18-pointer. I got to say, I don't have one of those. I'm in my kitchen, but I'm going to work on that the next time I get out to Texas. Me and Erika are going to say goodbye. We'll come in at the tail end and have a great session, and thank you.
Hey, Peter, before you leave, just let me thank you for allowing me to participate. Let me just tell whoever's listening just a little bit about Magna. my firm has used Magna consistently over the last several years for just about everything, including jury research, doing research on the internet to learn about different people that may have filed litigation against some of our clients. And there's been an occasion where, for whatever reason, we got in a bind needing a court reporter. And although this was my case, somebody selected somebody else who couldn't appear. We called Denise Spencer. We had somebody there that day in a location not too close to Houston. It was a good distance, but got it covered. So we thank you for that. And we look forward to continue working with you, Peter, and all your Magna team.
Well, thank you. And I look forward to seeing you in Miami, and I'll see you guys at the top of the hour. Thanks, and have a great webinar.
Thank you.
Thanks, Peter.
We have an incredibly great group of lawyers here today. They're experts in their field, and I have the easy job of being the moderator, and I'll try not to fumble that. We're going to talk about risk transfer and its impact on your clients and perhaps some of your insureds or people that you work for. We've got a panel that consists of Andy Barragry. He's in Milwaukee. Sorry that you have to be in Milwaukee, Andy, but go Brewers. And then we have Chad Dunigan is in Florida. A lot of sunshine over there. He's an expert in this area of the law. And then we have Bill. Bill is going to start off this presentation. He's somewhere in an undisclosed location in Arizona. I thought that was the Grand Canyon, but he corrected me. It's some other canyon that's pretty grand. I think it's Bryce Canyon or something. Bryce Canyon.
Yeah.
So we're going to start it off. Bill, it's yours, and lead the way. And if you have any questions, just put them up on the screen, and I'll try to get to them. Oh, I see some coming up here already. Hello to everybody out there. Okay, Bill, it's yours.
Thank you, Justice Medina. I appreciate your introduction. I thought I'd start with, talking about really what we're talking about today and give a short little history lesson. For those of you who don't know who I am, who Chad is, and who our firm is, we've been around for over 35 years. We have been predominantly a construction litigation firm, almost 99% on the defense side. And if you go back to the beginnings of our firm, you can realize that risk transfer has always been at the forefront of how we handle these cases. Back in the early days, it was primarily dealing with construction defect cases in California. Everybody there who was a general contractor or a developer would get added to the subcontractor's insurance policies for something along the lines of $50 or $100. Then the cases started coming in, and the insurers were a little chagrined to hear that they had to pick up the defense for a big developer for a $50 premium. So you can imagine that there was a lot of pushback, a lot of litigation, a lot of consternation over this whole process. Excuse me, but the problem was, unfortunately, these were huge cases, and everybody was looking and scrambling to figure out how to deal with it. So risk transfer became a very important component of the overall handling of these cases. And I can tell you that uniformly, and we'll talk about this when we get into the seminar a little bit more, uniformly, the cases, the courts found against insurers and primarily for their policyholders. I bring up that history only because this is more of a national now phenomenon. And I can tell you that when I came back to Arizona, I started as a lawyer in Arizona, moved to California, did this for a while, and came back. I can still remember one of the first cases I had, and I can remember going in front of this judge who looked at the sea of lawyers out on one case in his courtroom. And we started talking about case management and risk transfer and things of that nature. And I can still remember the judge standing up and saying, well, I don't care how they do it in California. This is Arizona. We're not going to follow the California model. And so you're going to hear a little bit about the California way, if you will. because eventually, in spite of that judge's short-sightedness, a lot of the California methods and procedures and case law and things of that nature have followed us to Arizona. They followed everybody to Nevada. And Chad's going to talk a great deal about how that's impacted Florida. He moved out to Florida about 8 years ago from California and started doing risk transfer out there. And again, I think there was at least a lot of pushback, a lot of scratching your heads, and a lot of people trying to figure out what this meant. Maybe Chad, you can take everyone through a little bit about your experiences and how that came to play.
Yeah, so like Bill, I've been doing construction defect litigation now, not quite as long as Bill. I won't say how long he's been doing it, but I'll let him speak to that. But I've been doing it now for about 21 years now. And like Bill said, I moved to Florida 8 years ago after handling, 99% of my work was in the construction defect arena, mostly with residential and commercial builders. And, doing it the way that it had been done in California for years, you get into a mode of you just believe that that's what everybody is doing. That's not really the case. When I moved to Florida about 8 years ago, I found pretty quickly that there wasn't a lot of risk transfer measures being employed in Florida, at least not the way that I had seen them done in California. And I will say, this is, I think, stating the obvious, but first and foremost, the buzzword we'd like to use is risk avoidance. In a perfect world, all of the defense group, the general contractor, the developer, the architect, the sub-trades, the vendors, suppliers, everybody that's involved in a project have the same goal, which is risk avoidance. And what we're really talking about today is when that risk can't be avoided, who's going to deal with it? And that was something that I encountered as a bit of a challenge for me personally when I moved to Florida, because on one hand, there had always been talk of risk transfer on the contractual indemnity side of that transferring. But from my perspective, my personal view was the body of law and the experience wasn't that developed on the additional insured side of things. And that's where I believe things have actually changed quite a bit in this state over the last 8 years since I've been here. And I know there's other states throughout the country that are kind of migrating in that same direction. And think what you will of California, good or bad, but it does seem that some of the states, or most of them, are trending towards employing what Bill is kind of referring to as kind of the historic California way, for good or for bad.
And I thought, again, that this to sort of conclude the history lesson, if you will, the interesting thing about risk transfer has been the phenomenon over the last 20 years where, in spite of all the court cases and favorable rulings that came the way of mostly the general contractors and developers, the subcontractors have been very vigilant in legislative solutions to what they call the unfair transfer of risk to them for things they weren't responsible for. And we'll talk a little bit about how that happens and why. But there has been a plethora of legislative efforts to limit indemnity rights of the indemnity holders. And some people like that, like perhaps Andy, and some people don't like that so much, like my clients for the most part. But it has resulted in a abandonment or going away from what the case law has been holding regarding specific versus general indemnity agreements and how those are enforced, to a statutory interpretation and in a way that is controlled again by the legislature. So with that, I'm going to start the slideshow and hopefully share my screen. And Justice Medina, is it up there?
It is.
Okay, good. And I believe if anybody's interested, we're probably going to be able to send you this PowerPoint. And I'll tell you regarding anti-indemnity law, I had a and Justice Medina will appreciate this, a University of Texas law student who's doing some clerking for our firm out there, put together a matrix in a Excel spreadsheet that lists by state, Alabama to Wyoming, et cetera, regarding the anti-indemnity legislation. We've got that on a Excel spreadsheet that we can send to people too if they're interested. So it goes through Illinois, Maine, New York, Rhode Island, you name it, the states up there. And if it's got it, it's got a cite to the indemnity law for those particular states. Let me try and do this and go. So the first obvious question is, and we'll get into personal injury cases as well, because this isn't strictly a property damage construction defect phenomenon, but with the construction defect litigation, it's usually more robust, if you will, because you usually have many more parties. You don't necessarily just have the, for instance, Andy's client, and maybe Andy should tell us, maybe this is a good opportunity for Andy. Maybe you should introduce yourself and tell everybody who you are and what your company does. That might be a good starting point for this.
Sure. So my name is Andy Barragry. I practiced in commercial litigation at Foley & Lardner for about 8 years and moved to BrandSafway in-house about just under 3 years ago. So I managed the company's general liability litigation. We are primarily an industrial access and industrial services company, also do commercial access. So what that means, practically speaking, most of our product lines are hoists and scaffolding and other ways to perform other essential work. So we are typically a subcontractor. And so my involvement with indemnification is probably the opposite of Bill and Chad. Typically we are on the opposite side of that. We are typically the party whom the contractor or others are looking to for indemnification or additional insured status. And so part of my role is managing that along with our outside counsel to reduce the company's risk. And then we have a contracts team that's also, reviews contracts, and that's one of the main types of terms that they focus on. Given the nature of the industry that we're in, most of the claims that we do face are personal injury related, but since we do work in residential, commercial, and industrial, we do occasionally get brought into construction defect cases as well.
So would you say that the vast majority of your caseload is related to personal injury or construction defect property damage?
It's probably about 90% personal injury or equipment damage, that sort of scenario, or business interruption. And then especially out in California, where we do a lot more of that kind of work, that's where we see the construction defect claims more often.
Thank you. So Arizona is a little, and I thought I'd start with Arizona in terms of what is a construction defect. Arizona is not one of the more, I wouldn't say progressive, but hasn't gotten as far as some of the other states with the codification of what a construction defect is. In Arizona, it's still, sort of up to the courts to make a decision on whether or not something's a construction defect, and usually is surrounded by, questions by an expert and testimony by an expert as to what something is. But Chad, maybe you can take us through Florida and Texas, and as most of the people probably on this call know, there's a Chapter 40 in Nevada and SB 800 in California that defines what a construction defect is and pretty much controls how the litigation goes on. But Florida is sort of a new venue for a lot of people. Perhaps Chad, you can take us through that, and Texas.
Yeah, I would say, unlike Arizona, at least in Florida, the definition of a construction defect is codified. Florida Statute 558 deals with that definition. And at the end of the day, the 558 statute is essentially a right to repair statute. It's generally what that is. And it's, in our view, it's for the benefit of the builder and the subcontractors, frankly, to give them an opportunity to deal with issues as they come up and perhaps make repairs where repairs are necessary before litigation ensues, and obviously to avoid the related expense there. But the one thing that's unique, construction defect definition is for the most part across Texas and Florida, and I guess Arizona to a degree. They're not that different. I mean, they're just different words, but they're all essentially saying the same thing. The one thing that's unique to Florida, though, is they codify this violation of the building code issue. And what that does is it gives rise to a claim. It's a statutory cause of action in Florida that I think is actually unique in this country, that you can actually bring a standalone cause of action, and our clients oftentimes face that risk when they, or more likely their subcontractors who they may have employed to do that particular work, where that scope of work deviates from the building code. Builders and subcontractors face statutory obligations or risk, if you will, when that is demonstrated. And Texas bill is not too far off of that in terms of its codification of the definition.
Hey, Chad, let me ask you this. On these issues, are most of them decided by the courts? Or are there arbitration clauses in these contracts?
So most of the contracts that we see, both on residential and commercial, do have arbitration provisions in them. And Florida obviously follows the federal rules, and they give real strong deference to the existence of the arbitration provisions. So more often than not, those arbitration provisions will be enforceable against the parties who entered into the contracts. And a lot of times what we also see is a kind of a mediate then arbitrate provision. We get that sometimes as well. But the overall goal, at least to our office, and most of our clients feel this way, is, to the extent there's a negotiated resolution that can be had, whether, mediation or some kind of non-binding arbitration, that's usually the strong preference. But if that can't happen, then most of our clients, at least when they're dealing with single family homes, Justice Medina, prefer an arbitration venue to kind of keep it out of the public eye. Typically a sense that arbitration is more cost effective than litigating in court. I do find, though, that when the cause of action, what's at issue, becomes more valuable, when there's more at stake, if you will, I find that more of our clients prefer not to arbitrate those issues, simply because you give up that right of appeal in an arbitrated forum that you can still maintain if you're staying in the court system. If you get a bad ruling in court, you can seek review. You get a bad ruling from an arbitrator, that's not going to be available to our clients. So I do find that the value that's at issue does in some ways weigh on which direction our clients prefer to go.
Bill, let's talk about some of the common defect issues.
Well, funny you should ask.
Look at that.
When you deal with these, it's just basically roof to soils. There's everything in between. I mean, we've litigated pipes, we've litigated the connectors between the pipes, the brass connections, whether they're dezinking or not. We've litigated the spacers between the dual pane windows and whether or not they should stay where they're originally put, or whether they're sliding into the field of view, and whether that's a defect or not, because it doesn't affect the actual performance of the window. It just looks ugly. We've dealt with all sorts of issues dealing with roofs and different types of things. We've dealt with, as the slide says, EIFs and sealants and different types of things like that, that sometimes work in New Jersey, but you put it out here in the Arizona sun and it tends to degrade a little quicker. You name it. There's fairly common is anything related to, believe it or not, in Arizona, related to water intrusion. Florida, obviously, it's a much bigger issue. I'm sure in Wisconsin, it's a much bigger issue, and as well as Texas. Chad, you got anything to add to that?
No, not really, but I don't know if this was appropriate, but we just got a question on what we were just talking about as it relates to building code violations. And someone asked the question of whether or not the Spearin doctrine provides a defense to a statutory building code violation claim asserted by a project owner against a contractor. And Now, Bill, I don't know if you want to deal with that in Arizona. I will say in Florida, that is a defense. That's a viable defense if you can demonstrate that you're dealing with a pure design issue, and you can, and you and your subcontractors are simply following a design, and you do it to the letter, and all of a sudden, through no fault of your own, you're having to deal with a claim. I figured I'd speak to it because it was a timely question on what we were just talking about. So if anybody else wants to comment that, they're welcome to.
Well, it's a fairly, I mean, the Spearn Doctrine's been around since 1901 or something like that, but it's a Supreme Court case, United States Supreme Court case, but it is one that's followed in most jurisdictions, and quite frankly, it's a good defense. I just want to motion for summary judgment on a wrongful death case down in Tucson in the federal court, where my client built the smelting plant for creating and making copper. And Phelps Dodge was the, now Freeport McMoran was the owner of the plant. And one of the workers there was electrocuted. And it was electrocuted because one of the pipes that they take the effluent out of the place where they stick the diodes that make the copper, collect the copper, became charged electrically. And we were able to get out because we proved, and the plaintiff's expert had to admit, that we built it according to the plan. In terms of any code violation or something like that, they tried to saddle us with knowing that, but that's really the design issue, not the contractor. So it works for a contractor, not so much for a design professional. The design people are selling to. So risk transfer. I love this slide, but risk
Bill,
transfer.
Sorry to interrupt you, Bill, but this is a great picture. And for those of you in the audience, if you look closely, this third guy right here, I think that's Peter Hecht, but go ahead.
Could be. I love this slide because it's an introduction to what I call the four lawsuits. In any case involving construction, there's always the four cases. There's the original claim by the plaintiffs, be it the owner, developer against the contractor, or the homeowner against the contractor. The contractor then has claims against its subcontractors. The contractor usually has claims against its own insurers. And then we look to the contractor's claims against the subcontractor insurers. And so the risk transfer portion really starts with the last three. And again, from my client's perspectives, numbers 2 and number 4 are the ones we try to focus on. And that's really what we're talking about here today. Theories of recovery are important, primarily because in the history of risk transfer, there's been a lot of litigation over whether or not a breach of implied warranty is something that would be subject to an indemnity agreement, whether strict liability should be subject to an indemnity agreement. There's been a lot of metamorphosis over the years regarding indemnity agreements. I can tell you that when I first started doing this back in the dark ages, most indemnity agreements were essentially cut and paste from the previous indemnity agreement and cut and paste from the previous indemnity agreement without any real thought or rhyme or reason as to how they were even read. It was just something that you put in a contract because the other contracts had it and no one really read it. Sometimes it was even worse. The indemnity agreement could be the shake of a hand because you didn't have a contract. But that's changed over the years, and now maybe Andy, you can talk a little bit, because I think I heard you say that you have a team within your organization who actually reviews contracts that you're entering into, and I'll bet they spend a great deal of time looking at the indemnity.
Yeah, absolutely. Our company put a lot of focus on that and got buy-in from management. to do that years ago, and the team has only grown. It's I believe 5 or 6 lawyers now, and basically their entire job responsibility or primary is to review these contracts. And typically, what happens, given the nature of our position in the chain, being a subcontractor, we're responding to the MSA or other agreement that the GC or whomever our customer is providing to us. And typically the terms are on indemnification and additional insured are, in their favor. And their job essentially is to try to push back against those terms and get the approvals needed if we are going to accept adverse indemnification provisions. And, depending on the revenue, the potential revenue from the project, the importance of the customer, and sophistication of the customer as well, we get those changes to varying degrees of success. But from my end, managing the litigation, I kind of see the tail end of that. So typically, we don't have the terms in our favor because we're getting sued by the GC. So,
you ever have situations where the indemnity agreement, I think maybe that's what you just said, is already pretty much in place with the other parties, and because you're late to the game, you can't negotiate a change?
I would say it has to do more with the bargaining power of the contractor. It's an essential part of our work, and in certain jurisdictions, especially in New York in particular, I found that it's very common to have pretty broad indemnification provisions in favor of the GC, and it's often difficult to negotiate away from that.
So not to leave out the construction site accidents, but again, as I indicated at the very beginning, this usually has fewer parties than a big construction defect case. I'm fighting now in one here that's got close to 20 parties, and 1,000 witnesses basically. But the construction site accidents, it seems like there's always 1 or 2 subs and the GC. Obviously, you can have more if it's more of a environmental type claim, but the run-of-the-mill fall from, I hate to say this, Andy, the scaffolding, but case that you run into is the first thing you want to look at is the interplay between the workman's compensation and direct actions, and whether or not there's even a claim to begin with that you won't have been transferred, because a lot of times the subcontractor has workman's compensation, and the question is, can they get around it? And the theories of liability, I assume, Andy, you see these all the time, negligence and negligence per se.
Yes, and I, in addition to that, I think I'd add sometimes we'll see product liability claims, particularly with kind of our own proprietary equipment that we have in certain divisions.
Okay. But it's important to know what the workman's compensation, and again, state nationwide workman's compensation statutes can sometimes be the exclusive remedy, and sometimes they lead to, they allow the injured worker to go ahead and sue third parties for the claim responsibility for the accident. So what I thought, I talk a little bit about the privet doctrine for those of you not from California. Basically, this is a doctrine that allows general contractors to avoid liability for the injuries of their subcontractor employees. And basically, it was based upon the fact that the Supreme Court of California felt like the subcontractor employees had a workman's compensation method of recovery, and therefore they weren't going to saddle the general contractor with responsibility, except for if they retain control over part of the independent contractor's work. And that's sort of a variation throughout the nation. Depends on.
Yeah, let me interrupt you though, Bill. I think my notes indicate that Chad is licensed in all 52 states, or pretty close to it. No, at least 4. Very impressive resume. Chad, how do you come across these control factors? I know that's a big issue in Texas, and there's some latitude there depending on the degree of control. So how does that impact your analysis and defense of these cases?
What do you mean, Justice, in terms of the control factors? What are you thinking of?
How much control does the contractor have over the sub?
Sure. So, I mean, in terms of on-site control, I mean, there's the obviously day-to-day management, on-site supervision that happens. But there's also some controls in place in terms of the documentation and insurance that gets secured for the benefit of the project and the benefit of the employees. And, you know, like Andy has seen, and I think Bill mentioned he's seen it as well, in Florida, there's also a fairly robust statutory framework that deals with workers' compensation and interplay with on-site work accidents that tend to happen. In fact, I had a case about 2 years ago where one of my clients, who was a general contractor, one of its subcontractors' employees was up on a ladder trying to pull a nail out of some wood, lost his balance as the nail gave way. He goes over sideways on the ladder right through a framed out window opening that didn't have a window in it yet, and he fell four stories down and he died. It was a tragic story, and as it played out in my world when it hit my desk was, you know, it was the estate of the deceased individual was filing a lawsuit against the subcontractor, his employee, trying to, like to use Bill's words, try to work around the workers' compensation statute by pleading gross negligence, which can be a mechanism to get around workers' compensation statutes. But they were also coming after our client as a general contractor under a theory of negligent job site supervision. And, you know, at first blush, our client was super concerned because they were thinking that they weren't going to get the same protections, the same workers' compensation immunity that the subcontractor was going to receive, given the employee-employer relationship that they had with the deceased individual. And we found, and we actually proved, we were successful in motion for summary judgment, proving that the general contractor had vertical immunity above the subcontractor, because in our instance, one of the controls you're speaking of, we had actually secured and maintained workers' compensation for the benefit of the project, including our subcontractors. So the give back there, Justice, was because our client did the right thing, so to speak, by making sure that there was insurance there for the benefit of not only the general contractor's employees, but also for the subcontractor's employees. The give back there was that they were able to avoid the risk in that instance by seeking shelter under the workers' compensation protections that were available for the subcontractor.
Great. How about you, Andy? Anything different up there in Milwaukee or in the states that you cover?
Yeah, so interesting. I mean, we do have litigation all across the United States, almost every state at some point in time. I will give just to add on to the what Chad just discussed. I mean, sometimes we get in an interesting position that kind of deals with an overlap of work comp immunity as well as indemnification. So just to give one example, you know, we've had cases where it's our employee who was, you know, injured while working on the job site, specifically doing work that was, you know, within the scope of his employment, the kind of thing that the activity that we would be directing as his employer. So, you know, obviously there is a work comp claim that we have to deal with that if that employee is injured, but typically then, as we were saying, you know, we have work comp immunity. However, if that employee of ours decides to sue the general contractor and the owner, as they often do, and tries to make a third-party claim out of what really should be essentially just a work comp incident, oftentimes if the indemnification or additional insured terms are not in our favor, you know, we'll get the lawsuit filed against us by the general contractor and the owner. They'll tender that to us, and it puts you in an interesting position, you know, defending that lawsuit, because effectively you're making the argument that your own company was responsible for this incident and your own employee was responsible for this incident in defending that general contractor and owner, and effectively that the general contractor and owner, they don't have that kind of control or supervision to be held liable for that subcontractor's work, that subcontractor being us.
Very good.
The interesting thing in terms of Arizona, not that anybody is that enamored with the Arizona laws, but we do have here for personal injury type claims, a statutory scheme that allows defendants to only pay for what they caused, in a sense. So we are a several state, not a joint and several state. So if there's 100% liability and you're only 30% at fault or 10% at fault because you're the GC, you can name the subcontractor who is protected and can't be sued under the workman's compensation statute as a non-party at fault. So you're effectively reducing your risk by the amount of fault for everybody else in the case or even out of the case. And that certainly then affects with the anti-indemnity statutes that we now have in Arizona, the ability to transfer even that last 10 to 30% fault, because essentially, as you'll find out in most anti-indemnity statutes, it really does break it down to you can only seek indemnity if you have to pay for somebody else's negligence.
Bill, let's talk about how they do things in California, so-called California way.
I'll let Chad take that one. He practiced there a lot.
What was the question, Justice?
Let's talk about the California way. This is the next slide.
Essentially, Chad was talking about this yesterday, so I'll give him a little heads up. But
I know the California way. Go ahead, Bill.
All right, but I mean, we're dealing with indemnity and insurance policies, and so now we're back to the broad spectrum, not just personal injury type claims. And Chad, take it away.
Well, the California way probably doesn't sound great, and I think when most people hear the California way for just about anything, they probably cringe or run screaming into the night in the other direction. So try to ignore the fact that we're referring it to perhaps a state that people may not think much of. But what this is intended to talk about is what Bill alluded to at the beginning of our presentation, which is for right or for wrong, California has a very developed body of law dealing with what we're talking about today, both in terms of risk avoidance and absolutely in terms of risk transfer. It's just true. And having moved from California to Florida and now practicing in Texas, and we're seeing it in other states, I'm sure Andy's seeing it too, is there's a lot that has been borrowed, let's say, from California in terms of how the lawyers there have worked over the years to get to where they are now. And a lot of what's born out of that has become very useful to our clients, at least, who are, like I said, mostly general contractors and developers, who are kind of sitting at the top of that risk transfer pyramid, so to speak, looking to their subcontractors, looking to their own insurance providers, the subcontractors, carriers, to be part of the resolution process when these claims come in. And, Justice Medina, what that really leads to is, trying to deal with the indemnity language in these contracts and making sure that people are securing the right insurance for the work and the risk that they're getting themselves into, because, words matter. I mean, these documents matter. You can get any old contract, you can throw any old indemnity language in there, and you too could wind up finding that contract is illegal because you run afoul of that particular state's anti-indemnity legislation. Or as a general contractor, maybe I could accept from Andy's client perhaps an additional insured endorsement that gives me very limited coverage. Perhaps it's ongoing operations only. But what I really want is completed operations. But the contract doesn't obligate him to give me anything more than the ongoing coverage. So that's kind of a lead in, I think, to the next slides, so we can get kind of more details on those issues.
Hey, Chad, before we go on to the next slide, I got a question that popped up here from Gary, and here's the question.
Okay.
Maybe Andy can help us with this. Here's the question. Do some work comp policies have Part A, employer liability coverage, or something like that? Have you run across that?
So I guess I'm not that familiar with it, because we have a work comp team that actually separately handles our work comp claims. I am familiar with the term Part A and Part B coming up in the context of a gross negligence claim. But Bill or Chad, do you have any background in that?
Well, Chad's on mute, so he must not have any background. No, I'm not really familiar with Part A and Part B. I mean, I've seen them in accords, but that generally deals with liability and automobiles. So I don't think that's the work comp side of things. But I would imagine that obviously there's different types of claims for different types of insureds, and I don't know if you get as Chad was talking about, a silo where the coverage goes up the ladder to not only the subcontractor who pays for it, but also the general contractor and or any higher subs if they're a subset. But I don't know if that's for sure what that's talking about.
Let's go ahead and go on to the next slide. We've got about 15 minutes or so to wrap up this great presentation.
So I thought I'd talk a little bit again about Arizona, but because it's sort of indicative of what's going on around the United States. Arizona used to have one statute that essentially outlawed or made void, prohibited getting indemnity for your sole negligence. So you had to be careful when you wrote the indemnity agreement that it didn't require coverage for your sole negligence. But, having said that, there was in the dichotomy between general and specific. California calls them type 1, type 2, and then there's even a type 3 indemnity agreements. And essentially what those said is you have to be very specific as to your desire for indemnity. You need to be very clear in how you say it. Fast forward to November of 2019, pre-COVID, obviously, Arizona passed an anti-indemnity legislation that essentially is ARS 32-1159 that then prohibits indemnity of any type in agreements between private parties. And essentially, I love this part of the legislation. It says it can be written or oral. I'm not sure how you have an oral indemnity clause, but if you try and enforce one, you're not going to be able to do it here in Arizona. However, they added a .01, which then applied to dwellings. So you can get indemnity for dwellings as opposed to commercial contracts and things of that nature for property damage defect claims, but only to the extent that the negligence was caused by the person giving you indemnity. So it essentially codifies the idea that you have to pay for what you did and you don't have to pay for what somebody else did. So it unfortunately creates a situation where when you're in the throes of a mediation, arbitration, or trial, it tends to divide the defendants to the benefit of the plaintiffs because you're always trying to prove the other guy who's somewhat negligent. This was, I think it will ultimately, assuming you can't come to a deal with all your subcontractors before you go to trial, this will lead to probably higher verdicts and scarier trials. So that's Arizona. It's very simple. That's what they've done. California, they've got their SB 800. I'm not going to spend a whole lot of time on that, but they've essentially outlawed or, again, prohibited contractual indemnity. That took place back in 2006 first and then 2013. So most contracts now, you're dealing with indemnity clauses that, again, are not usually enforced. Nevada, Chapter 40 sets forth indemnification provisions for residential construction. Again, it allows a subcontractor to indemnify and then hold harmless defects, but they call it void and unenforceable. So how you get there in Nevada is obviously very difficult, and that's been in place since 2015. Texas and Florida, again, I'm going to let Chad speak to those simply because he's licensed in both those states.
Sure. So in Texas, like a lot of other states, their anti-indemnity legislation exists. It was codified in 2012, and you see it's codified through the Texas Insurance Code, section 151.102. The unique thing about Texas is that they've got some very tricky exceptions to the anti-indemnity legislation. For example, one of the exceptions is employee claims for bodily injury or death. Another one that I think that's important for today's conversation is, there's an exception for residential construction for single family. In fact, it talks about an exclusion for construction contracts pertaining to single family homes, townhomes, and duplexes. So the anti-indemnity excludes those situations. Very strange. It's different than other states. Obviously, Texas is unique in that way. It kind of a growing body of law that's still untapped, I think, is how those words are going to apply to things like condominiums and apartments, kind of other residential dwellings that don't necessarily meet the exact words of the statutory language. In Florida, you've got your anti-indemnity statute as well there that's set out as Florida Statute 725.06. Also states that you cannot seek indemnity for your own active negligence unless you do certain things. You can do that as long as there's, you set out a monetary limitation to the indemnification that must bear a reasonable commercial relationship to the contract. And you also have to make sure that the indemnity obligation is set forth in the project specifications and bid documents if you have them. The one thing you have to keep in mind is, I know we're talking about the contract, but there is direct interplay, Justice Medina, with the contractual language and the net effect that it may have on your insurance coverage. I mean, one of the things we're going to try to talk about today is your, additional insured aspects of risk transfer and dealing with the insurance carriers. The pitfall obviously is, if you're a general contractor like my client, who has a contract that maybe has run afoul of these anti-indemnity legislative requirements, when you tender your defense as an alleged additional insured on an insurer's policy, if the endorsement that you're tendering under happens to be a blanket endorsement, you may have some issues there, because we have found that some insurance carriers are starting to take the position that when they're looking at the insured contract under the definition, as that term is set forth in the policy, they're looking at four corners of the language in the indemnity provision. They're saying, hold on a minute. If you're in Florida, for example, your indemnity provision runs afoul of 725, that particular statute. So because you don't pass muster under that anti-indemnity legislation, we believe your contract that you're tendering under for blanket endorsement purposes is an illegal one and an unenforceable one. So then they look to the terms of the policy and they say, well, look, you may not even have an insured contract under the terms of this policy to qualify as an additional insured, because the contract you're tendering under for blanket endorsement purposes, you don't have a contract at all. Like, you don't have one. So long as it's unenforceable, we're going to treat it as illegal, void, doesn't exist, never did exist. So as a carrier, they may look to those arguments to avoid their coverage obligations.
Well, that's a great explanation, Chad. I tell you, for anybody listening, Chad and Bill and Andy are all experts in this area of law. I'm sure you could call them for any help that you need.
So we're going into what Chad just alluded to, and the question is additional insured endorsements. As I said, there's been a lot of litigation over this over the years, primarily because it's almost a situation where the insurers' premiums were not relatable to what their risk was, and a lot of the additional insured situations were simply not well thought out. Now that's changed obviously over the last 15 years or so because of all of this type of litigation. But Arizona,
we have about 5 minutes, and for the audience, if you have any questions that you want us to consider, go ahead and pop them up on the screen, either to me or to all the panelists, and we'll try to get them answered.
And you know, quite frankly, I think most people know that the additional insured endorsements have undergone from the 1985, 2011 that provided broad coverage. Insurers have done their best over the years, and the International Insurance ISO group has been you know, trying to revise what that language does. But I'll back up one slide. There have been, unfortunately for the insurance companies, there's been most decisions do not go their way. And even for endorsements that are trying to limit the exposure to ongoing operations where once the project is complete, the policy is no longer in play. Courts have been finding ways when there isn't any insurance otherwise defined to reach back to those ongoing operation endorsements and say, well, I know what you meant, but you didn't really say it right. You know, I'm reminded of a seminar I once went to and dealing with medical malpractice. And I remember the lawyer getting up there and saying that, you know, doctors should never malpractice anything because the human body never changes. Yet if you're a lawyer, there's no such thing as malpractice because the law changes almost daily. And that's almost the way this is, because it seems like no matter what the insurance companies come up with in terms of their endorsements to try to prohibit or limit their exposure, for whatever reason, courts are routinely willing to find ways around that language.
Hey, Bill, we got a couple of minutes here. I've got a question that's popped up. It's a good question. I want to see if we can get an answer to this question. Then I want to talk about the 8 corners rule in Texas. There's an opinion out there, but it was written by Justice David Medina. It's Guide 1 versus Fiedler Road Baptist Church. If you have a pen, everybody, it's 197 Southwest 3rd, 305. Eloquent opinion. Here's the question. What are some good negotiation strategies for GCs against subs for indemnity, especially when dealing with plaintiffs that are presenting inflated demands?
Well, I guess if you're trying to resolve the case, you need to sort of focus on the plaintiff and, quite frankly, provide a united front. You know, I've tried a number of cases where I've convinced the subcontractors before we go to trial that, you know, this is the way we ought to divide it up and not point fingers at each other. And every time I've been successful in convincing the subcontractors to trust me that we're not going to point fingers at each other, we've been very successful against the plaintiffs. In terms of negotiations, once the plaintiffs see that you're united and that you're not going to say, you know, not going to divide and conquer, I think that's the best method you have for negotiating against inflated claims. Chad, what do you think?
Yeah, I think that's right, Bill. I mean, I find sometimes in the role that we play as counsel for the general contractors, unavoidably find that you speak out of both sides of your mouth, depending on who you're talking to. And like Bill said, you know, typically we try to put up a joint defense against the claimant or the would-be plaintiff's claims, like Bill said, to try to demonstrate and just avoid the risk, right? So we don't have to talk about transfer. So much as we can drive this case down and avoid the risk for the betterment of the whole defense group, the less we have to talk about as a defense crew, trying to figure out how we're going to apportion fault and chop up the risk and try to resolve the case. So, you know, usually we do have situations, not usually, I'll just say we do have situations when there's some merit to the claim and you still have to resolve it. So on one hand, while we're fighting the good fight, so to speak, as a defense group, we do, at least in my office, we structure a different lane that we go on, Justice Medina, as we're handling the case, where we have a defense lane where it's just us and our subcontractors. And sometimes we have to have pretty candid conversations about what's going on and our expectations of those subcontractors whose scope of work, unfortunately, may be implicated by the claims. And sometimes we have to have those tough conversations talking about the things we're talking today about. Hey, remember that contract you executed. You know, there's a couple provisions in there that says in the event of a third party claim or a lawsuit that we're dealing with, and the claim arises out of your work, or at least to the extent that it does, this document that our client signed several years ago says that when this very thing happens, you're going to do certain things. You're going to step up and provide a defense or indemnity for me. You're going to show me copies of your additional insured endorsements that you said you would secure for everyone's benefit. So where are those insurance papers so that we can put the carrier on notice? Because from our perspective, as an additional insured, our clients feel that they're an insured on those policies, just like and no different than the subcontractors who originally purchased those policies. And sometimes just there's a little misnomer in terms of referring to additional insured as if there's something different than good old-fashioned named insured. They're the same thing. We just call them different things so that we know which person we're talking about or which company we're talking about. But at the end of the day, once an entity or a person is added to the policy by way of an endorsement, but they're an insured just like the original named insured who secured the policy and paid that premium in the first instance.
Justice Medina, do we still have any time for you to tell us about the 8 corners rule in Texas?
Yeah, do it.
Just a great opinion. I think you have a good summary there. You look at the 2 documents and try to make a coverage decision on what the contract says and what the petition says. And that's been there's been some effort to try to expand that, but that's certainly a good start. I typed the site of the case up there for everybody to look it up. If they need additional information, they certainly can call me. I see Mr. Hecht is there. I guess our time has expired.
I'm back I'm in my kitchen. I'm not done. I just made myself an omelet. Just kidding. Hey, Bill, I just want to know if I could charge for your power. Everybody wants a copy of these slides. You did a really great job. So if anybody wants a copy of the slides, it's only $9.99.
Wait.
Oh, wait, there's more. Yeah.
All right, $99.99 plus 3 depots with Magna. Contact Erika for details. No, seriously, transferring the risk. I still probably need another class on that, but it was a good topic. We held a great audience, a little bit over 100 people, and I give you guys the Jersey thumbs up. I'm coming to you live from Exit 4 in the Turnpike, and I'm not exactly in Texas, Arizona, or Florida, or LA. And where were you, Andy?
Wisconsin.
Okay, so you're kind of like in the cold weather. There's nothing for you to do either, right? You and I have a lot in common.
Yeah.
We have more webinars coming up. Justice Medina, as always, you're a fantastic moderator. Bill, like I said, you can see in the chat bar here, everybody loves your slide deck. So if it's okay with you, may we circulate the slide deck?
Absolutely.
Okay, great. And
yeah, and I like I said, I also have the Excel spreadsheet with all the anti-indemnity statutes from across the state. And I think I've sent that to Erika, but if I haven't, I will get that to you.
Yeah, Erika, why don't you share your email address on the chat bar? So if anybody wants a copy of the slide deck, they can email you directly and she can get you. And if they want to wait an extra day, we could probably get an autographed copy by Bill as well. So if you want to get a signed copy, and maybe a couple extra days, we can get Andy and Dave and Chad on there as well. Andy, it's great seeing you. Honestly, I don't want to see you again until Miami. That's where I want it to happen. And Chad, drive on down from Tampa to Miami. It's not a bad attendance fee. It'll be worth your while. And Bill, I hope you make it out there too. Everybody, thank you for your time. What a hell of an 18-pointer behind you over your right shoulder, I guess. And God bless, stay healthy. And if you have to schedule a deposition in the construction defect-based place, please give us a call at 866-624-6221. Ask for me or Erika, Malady. Thank you. Have a great night.
All right. Thanks.
Be well.
Thanks, Erika. Thanks, Justice Medina. Andy, nice to
Thank you,
meet you.
Bill, Chad.
Thanks, Justice Medina, Andy, Bill, Erika, everybody. Thanks so much.
Erika, send me a couple of those Vikings, okay? I have a headache.
I got you.
Okay. Bye-bye, Bill.
Bye, everybody.